In this video, again, we're talking about hearsay, and again, we're talking about specifically definitional hearsay. We're not worried about any of the exceptions or what causes it to be weeks of instruction instead of just a week of instruction. We're talking about definitional hearsay, and not the most popular definition that you'll learn in law school, but instead the 801D definitions, the times when the rulemakers say under the federal rules that these situations are not hearsay. And specifically, we're focusing on statements by party opponents under 801D. So recall that the opponent invokes the entire Article 8, right? Objection hearsay. As soon as you say objection hearsay, what you're saying as the opponent is, I believe this is one of those out-of-court statements and that the proponent is offering it for the truth of the matter asserted to prove the words that are in quotes. This starts us on a path of the evidentiary discussion. This starts us towards the responses and the acceptable pathways of a response. The first one that we've talked about in a different video can be, no, it isn't. It doesn't meet this definition. It's not a statement, or maybe it's not out of court, or most popularly, I'm not offering it for the truth of the matter asserted. I'm the proponent here. I know why I'm asking these questions of this witness or why I'm introducing this document, and I'm not offering it to prove the matter that's in quotes. I'm not offering it for its truth. And then you see the exceptions over on the right for reliability or necessity, or maybe even the residual exception under 807. But we're going to talk about today the time when the rules say, you know what? In these circumstances, this is not hearsay. These are rules designed for the proponent. If one of these situations is in play, then the proponent just gets to say, no, it isn't. This is not hearsay. I have my own definition. I see your definition under 801C. I have my own under 801D that says this is not hearsay. And the not hearsay will trump out. The not hearsay will win. And we're going to talk about a specific one. Statements against parties, or sometimes said statements by party opponents, or the one that I cannot tolerate and the one that I do not like and the one that only serves to confuse, is you will hear these referred to as admissions. And for those of you that heard me speak on this, know that I'm not alone in the fact that I dislike the word admissions, mainly because admitting something or looking at the content of the statement at all to whether it relates to an admission or that it in fact admits anything whatsoever is irrelevant. It doesn't have to be an admission. It doesn't have to serve to admit anything. Think statements against parties or statements by party opponents, and you'll be much served. So here's what we're talking about. You remember my chart before that talks about whether something doesn't meet the definition or other arguments and other things. Here we go under 801D. There's these three different categories, and we're focusing today on 801D2A. A through all the way capital E, but focus on A today because it's very simple foundation. Statements by party opponents. Statements offered against. Stay away from the word admissions. Here are the foundational requirements for not hearsay under this rule. First of all, it has to be offered by a party opponent. Think about that. Offered by a party opponent. That is, who's the party opponent and who said it. The analysis for these types of statements are very, very short and very easy, but unfortunately often very easily missed. This is as an issue spotting matter is missed all the time on law school exams, on the bar exam, and unfortunately in practice. So if we look at the beginning of the chart, if it's a party's own statement and it's offered by the party opponent, who said it? Who's offering it? The only two questions you need to ask. So in a civil case, if the defendant said something at a definition and it's offered today by the plaintiff, game over. Doesn't matter what the statement is, doesn't matter if it admits anything, doesn't matter if it constitutes an admission. You simply say, Your Honor, objection hearsay. As the proponent, Your Honor, this is the defendant's statement. I am the plaintiff. It's offered then by a party opponent. Game over. How about in a criminal context, Your Honor? This is a statement by the criminal defendant. It's offered by the prosecution, a party opponent. Game over. The only place it gets tricky in a criminal context is a victim is not a party. Oftentimes other affiliates of the government are not parties. So look strictly to the caption. Who is a party opponent? Now think about it. If a defendant said something that he really likes but doesn't want to testify at trial, said something in the media, said something at a prior statement to police officers, a defendant cannot introduce his own statement because although it's a party's own statement, it's not offered by a party opponent. It's offered by that party. It falls out of this rule. Can't introduce your own statement. You could always introduce the person on the other side of the V. And if you think about it, this rule is not based on our typical reliability or hearsay principles. This rule is based on estoppel. That is, if you said it, You're going to eat it at trial. If you said it and the other side wants to introduce it, guess what? It's coming in. That's it. You can always take the stand to explain yourself because you're a party to this action. On parts of this rule always have to do with not only being offered by a party opponent, but it could be by a party or attributed to a party. So what do we mean by that? That's the 801 D2B, capital B, C, D, and E, all the way to E, conspirator statements. And they look like this. So the easy one is party's own statement. If it's said by Joey, who's the defendant, and it's offered by the plaintiff, game over. If it's said by Meredith, who's the plaintiff, and offered by the defendant, game over. Said by a party, offered by a party opponent. That is your response. Automatic winner in objection hearsay. And it's going to be the easiest response. So to the extent a question ever asks you, what's the best response? It's always going to be this, if it fits. Party's own statement offered by a party opponent. What do we mean by when we say attributed by? Maybe it was adopted by this party. That is, it was said right in front of someone. And they adopted it. I agree. Maybe they didn't say the specific statement, but they said, I agree. Maybe they signed a petition that says something in some way that they adopted it. So it's the fundamental equivalent of being the party's own statement. Also still has to be offered by the party opponent. Maybe it was someone that was authorized. Please go to the meeting and vote yes. Sure, I, as the party, didn't make the statement, but I authorized someone to speak on my behalf. So it's fair to attribute. It's fair to say. Still has to be offered by the party opponent. So if the plaintiff in a civil case gives authorization to some third party to go make a statement, well, that statement by a third party can be brought in because it can be attributed to the party, and so long as the other foundational requirement offered by the party opponent. You see where this is going. Could be by an agent or by an employee, someone that's acting within the scope and during their employment, right? If I say, hey, you're as part of your employment, as part of your agency relationship with me, the party, you should say this, and you have the authority to do this. My media person, my public affairs officer, those people are authorized, and it's part of their job to speak on these matters as long as it's within the scope and during their employment. Well, so too, that's going to be attributed to me, the party, oftentimes for that rule, a corporate party, as long as it's offered by a party opponent. You're really looking at who said it and who is it offered by here at trial. The last one's subject for a separate video, but could be a conspirator statement. If the defendant himself said it, we don't need to go past A. Defendant himself said it, offered by the government, offered by the prosecution, it's over. But what if it isn't the defendant in the caption? Instead, it's one of his conspirators who's not in the caption. Well, I might be able to attribute the conspirator statement to the party who is in the caption, so long as it's still offered by a party opponent. But we have to do some analysis, and we have to go through the test and figure out whether it in fact qualifies as a conspirator statement. For this purpose and the purpose of this video, what I really want to leave you with is for statements by party opponents or statements offered against parties, not admissions, don't get confused by that word. Really what we're looking at is who's making the statement. Who made the statement? Who is the declarant? Is it one of the parties in the caption? Secondly, who is offering that statement here at trial? Is it the opposing party? If it was the defendant, is it now the plaintiff? If it was the plaintiff statement, was it the defendant now at trial who wants to offer it? If it's the opposing party and the party's own statement, done deal. Not hearsay under 801 D2A. This is a statement by a party opponent. And just know that there are these other circumstances, capital B, C, D, and E, that even though that wasn't technically said by the party, offered by the party opponent, we're going to find some way to attribute it, to draw a dotted line to that party who's in the caption, and it will still be then attributed to a party and offered by a party opponent. Here's some examples. Prosecutor offers defendant's confession. Why do they get to do this, even though he has a right to not testify and a presumption of innocence? Because he said something and it's offered by the party opponent. Every confession comes in at every criminal trial, subject to a few other challenges that are unrelated here. And the reason it comes in as a matter of evidence, as a matter of hearsay, is because it's the defendant statement, party, offered by party opponent, prosecutor. Done deal, 801 D2A. Civil defendant offers deposition testimony of plaintiff. Notice we're not even saying what the testimony is. Civil defendant, offered by plaintiff, statement by plaintiff, offered by civil defendant, done deal. Civil plaintiff offers a diary entry written by the defendant. Notice it doesn't have to be formal, like a deposition or testimony or even a confession or statement to the police officer. It could be a diary entry. It could be spray paint on the wall. So it's by the defendant, offered by the civil plaintiff. Prosecutor calls defendant's girlfriend to testify. This is the one that gets people turned around because we're introducing those two different concepts, a witness and a declarant. Who's the one who said it? Who's the declarant? Defendant told her about the crime. Well, if defendant told her about the crime, defendant is declarant. The declarant. Doesn't matter that the witness is the girlfriend, the mother, or anyone else who heard it. We're called a witness to talk about what the defendant said. The defendant owns the quote. And who's offering it? Prosecutor. Done deal. This is a not hearsay statement by party opponent. Civil plaintiff offers emails sent by the CEO of a defendant corporation. You can see this might be attributed to, or it might actually be if the defendant corporation, maybe it's an actual statement by party opponent. Either way, one side is offering it, the other side said it. Civil plays a video of the plaintiff making statements. See, it doesn't matter the form that it comes in. It doesn't matter if it's written or if it's a witness testimony or if it's a video that contains statements. Civil defendant is the one offering it. Plaintiff is the one that said it. And so on and so forth. Offers letters written by the defendant to his family members while he was in jail. Sounds offensive. Sounds like they shouldn't do that. Defendant's statement, prosecutor's offering it. You're just deciding evidence. You're just deciding hearsay. Look at the sides of the caption. United States versus X, United States versus Y.